Vernon and Doreen have the same house, the same retirement accounts, and the same 2 adult children. They even had the same attorney who prepared their estate documents back in 2008. Both died in 2024, but their legacies look nothing alike. Vernon died with a properly titled revocable living trust and all his beneficiary designations in order. He had a pour-over will, a healthcare proxy, a durable power of attorney, and a HIPAA authorization. His estate went through probate in 97 days, and his children got their inheritance in 5 months. Doreen died with a valid will that had not been updated since 2011, and no trust. Her retirement accounts named her estate as the beneficiary, which is a complete disaster. Her healthcare directive was outdated in 17 specific ways that became apparent during probate. Her estate went through 2 years and 4 months of total administrative hell. Her children spent $87,000 in legal fees, just fighting over assets the will ignored. One of them has an actual estate plan, the other has a folder of useless paper. The difference between these 2 families is not just money, it is foresight. Chapter 1. You probably think estate planning is only for the rich. The number that should disabuse you of this notion is $12.9 million. That is the amount exempt from federal estate taxes in 2025 under current law. Below that number, there is no federal estate tax, so you can finally exhale. But the federal exemption is not the relevant number for most people. The real numbers are the state tax exemptions, the cost of probate, and the cost of conflict. These are not luxury problems. These are just standard middle-class problems. They come from having enough assets to matter, but not enough planning to manage them. The median home value in the United States is over $400,000. The median retirement balance for older households is over $200,000. Add a paid-off house and a pension, and you have an estate worth $800,000. That is absolutely subject to state estate taxes in 14 different states. It is absolutely subject to the heavy costs of probate, and it is absolutely subject to the legal costs of family conflict when the will is unclear. Probate is the legal process of validating a will and administering an estate under court supervision. Every state has a probate court, and every estate that lacks a properly structured trust goes through it. The average probate process in the United States takes between 6 months and 2 years. The average cost is between 3 and 7% of the gross estate value, plus attorney, court, and executor fees. For an estate worth $800,000, the average probate cost is between $24,000 and $56,000. That money goes to attorneys and courts, not to the children. Doreen's estate was worth approximately $780,000, and the probate process took 26 months. Her children paid $87,000 in legal fees, which came out of the estate before distribution. Doreen's children received approximately $346,500 each. If she had established a revocable living trust, the legal fees would have been $4,000 to $8,000. The distribution would have taken approximately 90 days, saving them $73,000. Doreen's failure to update her estate plan cost her children a year of full-time work. That is the cost of a folder of documents that stopped being adequate. It is a specific, quantifiable, real number that most people never calculate until it is too late. Chapter 2. Let us take apart what Vernon did right, because the trust is only as good as the funding that accompanies it. Vernon's attorney created a revocable living trust in 2015 and funded it properly by retitling his assets. This is the step most people skip, and the reason most trusts fail to achieve their purpose. A trust without assets is an empty box, but a trust with assets is a mechanism for avoiding probate. Vernon transferred his house, bank accounts, and investment accounts into the trust. He changed the deed on the house and the registration on the accounts. It took 3 months. It was boring, and it was not complicated. It required attention to detail and a willingness to do paperwork. When Vernon died, the trust did not go through probate. The trust document controlled the distribution of assets without court involvement. His children received the assets without a judge, without a hearing, and without a waiting period. There were no legal fees proportional to the size of the estate. Vernon's retirement accounts had beneficiary designations that named the trust as the beneficiary, rather than naming his estate or naming his children directly. This is critically important. A retirement account that names a beneficiary bypasses both the will and probate. The assets go directly to the named beneficiary, and if the beneficiary is a trust, the trust controls the assets. If the designation names a person who is deceased or incapacitated, the account goes to the estate, which goes to probate. If the designation names a minor, a custodian must be appointed under the Uniform Transfers to Minors Act, which involves court. If the designation names an ex-spouse, the ex-spouse inherits regardless of the will, which has destroyed family relationships. Doreen's retirement accounts named her estate as the beneficiary, and her attorney had told her in 2008 that it was fine. It was fine in 2008, but by 2024, it meant every dollar of her savings went through 26 months of probate. It was reduced by $87,000 in legal fees and was distributed according to a will that had not been updated. It missed the birth of a grandchild, the purchase of property, or the change in state tax law that occurred in 2017. Chapter 3. Here is what the typical American gets wrong about what an estate plan needs to include. The gap between a complete plan and an inadequate one is measured in years of court hearings. It costs tens of thousands of dollars in legal fees and destroys family relationships that never recover. The documents most people think constitute an estate plan are a will and possibly a healthcare directive. Those documents are necessary, but they are not sufficient. A complete estate plan for a retiree includes at least 6 documents. First, a revocable living trust, which holds assets during your lifetime and transfers them without probate at death. Second, a pour-over will, which catches any assets that were not transferred into the trust and sends them there. Third, beneficiary designations on all accounts reviewed and updated at least every 5 years or after any major life event. Fourth, a healthcare proxy, naming someone to make medical decisions if you are incapacitated. Fifth, a durable power of attorney, naming someone to manage your financial affairs if you are incapacitated. 6. A HIPAA authorization, allowing your named agents to access your medical records during incapacity. Without this, your agents cannot get information from doctors, even if they have legal authority to make decisions. Vernon had all 6, while Doreen had only 2. The gap is not academic. It is the difference between families. One receives an inheritance in 5 months. The other spends years in probate court. They argue about beneficiary designations and grandchildren's claims to the estate. The American Bar Association's 2024 survey found that conflict is the largest driver of legal costs. Most family estate conflicts are not really about the money. They are about the feeling that one sibling received more than another, or that the parents' wishes were ignored, or that an attorney took advantage of them. A well-drafted plan resolves these conflicts before they poison the family. Well, Chapter 4. There is a tax dimension that applies to a significant portion of the population. It is the generation skipping transfer tax that most planners never mention unless you ask. The federal estate tax exemption of $12.9 million sounds large, but the exemption is scheduled to sunset, reverting to $7 million in 2026. For couples with combined estates above $14 million, the sunset creates a planning urgency. Even for smaller estates, state tax exemptions create obligations that are frequently overlooked. Washington has an exemption of $2.193 million, while Oregon is only $1 million. Massachusetts and Maryland also have exemptions of $1 million. If you live in Washington and have $2.5 million, you are subject to the estate tax. The state estimates that 4,200 estates were subject to the tax in 2023. The average tax paid was $1.8 million, which is not a number that only affects rich people. It affects people with a normal retirement home, some accounts, and other assets. Without planning, heirs could owe taxes that were completely avoidable through proper trust structuring. Vernon and Doreen lived in Ohio, which does not have a state estate tax. But Vernon still planned, while Doreen did not. Vernon used his estate plan to transfer $400,000 to his children. He used a series of annual exclusion gifts of $18,000 per person. These do not count against the lifetime exemption and require no tax return filing. In 2024, he gave $18,000 to each of his 2 children and 4 grandchildren. That is $108,000 transferred tax-free in a single year. Over 10 years, Vernon transferred over $1 million using the annual exclusion. This provision is authorized by IRS code and has existed since 1981. Doreen's children received their inheritance through probate, with all the associated costs. Vernon saved $73,000 in legal fees through his well-drafted trust. Doreen's children paid for her planning failure with money they had already spent. Chapter 5. The conversation about estate planning that nobody wants to have is not about documents. It is about the conversation with your children that those documents represent. Vernon sat down with his children in 2015 after the trust was established. He told them what the trust said and why he made the decisions he made. He told them who was named as executor and who was the healthcare proxy. He answered their questions and listened to their concerns. The conversation was not comfortable as it involved his own mortality. It involved money, which is even less comfortable, but it happened. The children knew what to expect, and there would be no surprises. They knew where the documents were and exactly who to call. Doreen did not have that conversation because she was private about money. She believed a folder from 2008 contained everything her children would need. Her children learned after her death the folder was missing critical documents. The beneficiary on her 401k named her estate rather than her trust. A rental property she bought in 2015 was never formally transferred into the trust. The attorney who handled the purchase simply did not know the trust existed. The healthcare directive named their father, but he had dementia and could not decide. The backup proxy was named in a document that was not even in the folder. They spent 3 months finding it and 2 months getting a court to recognize it. The gap between Vernon's estate and Doreen's estate is not $73,000. The gap is the conversation, and the documents are just the artifact of that conversation. The conversation is the whole point. It is where you decide what you value, what you want to protect, and who you want to protect it for. The conversation is where your children learned that you thought about them after you were gone. You cared enough to make decisions, rather than leave them to make decisions for you. You respected them enough to tell them the truth about what they would receive. Vernon had that conversation, so his children knew exactly what to expect. The folder Doreen left was not a plan. It was merely a hope that the documents would be adequate, and a hope that her children would not fight. A hope that the attorney had thought of everything. Hope is not a strategy. Vernon had a strategy, but Doreen only had hope. The difference cost $73,000. It also cost 2 years of her children's time. It cost something that cannot be quantified, which is the relationship between 2 siblings. That relationship was damaged by the process of dividing an estate that was not clear. The number most people never calculate is not the cost of the attorney. It is the cost of the conversation you did not have. Have the conversation, then call the attorney. The conversation makes the documents meaningful. Without the conversation, the documents are just paper.